First, though, to our top story, the federal court decision dismissed the government's challenge of a compensation order for First Nations children. Ottawa, therefore, on the hook for billions of dollars in compensation related to the on-reserve child welfare system. It had previously been ordered to pay each affected child $40,000. Marc Miller is the Minister of Indigenous Services. Minister Miller, thank you very much for joining us this afternoon. This came before the federal court because a human rights tribunal made this decision. The federal government appealed that decision, and it has the option to appeal that decision once again. So I suppose I will begin our discussion very clearly by asking, will you appeal the decision once again?
Yeah, thanks for having me on, David. And I get that everyone wants an answer to that as quickly as possible. I think we need to bear in mind that this is a decision that came out 2 hours ago, and it's something that we are reviewing quite carefully. It's over 100 pages. And deals with some very complex issues that the Crown believed it had some very important challenges to the CHRT. It wasn't a challenge as to whether to compensate the children, but jurisdictional issues in and around the role that the Canadian Human Rights Tribunal plays. So we are going to look at it carefully and give it the review that is merited. So I can't confirm that to you at this time, but I do understand that people want that answer as quickly as possible. It does provide a path forward in terms of going back to discussing with mediation parties as to how and when to compensate these children that have been affected.
Okay, so you talk about mediation parties
by the child welfare system.
Yeah, let me ask you, because you're talking about mediation parties. So the tribunal said $40,000 to each child who was affected by this, and you have said in the past that the ultimate compensation perhaps ought to be more than that. And if that's the case, why not just begin the payout now? Why not just give the $40,000 and then determine what more is needed?
Well, I think it's quite clear to your initial point that there are people that have suffered horrific harms at the hands of the child welfare system, sometimes over a decade, and they will be entitled to more than $40,000. There are, because of potentially the age of the children and the overlapping complexities in having two class actions overlap with the Canadian Human Rights Tribunal dealing with the same children, the need to sit down and parse all of this out. It's something that cannot and will not be done in the public sphere, but certainly today's ruling does provide that opportunity, and the judge said it quite clearly, to acknowledge the work that's been done, but also the work that needs to be done, whether it's long-term reform and compensation in a framework that doesn't re-traumatize these people that have already suffered egregious harm.
Okay, I acknowledge that this process began 14 years ago. It preceded your government, but your government has been in power for 6 years now and is about to go on to however long this parliament lasts this time around. Why has compensation not happened yet in that time? I mean, it's not as if this was an absolute barrier to compensation. There could have been a parallel process. Why has compensation not yet happened?
Yeah, and let's be clear, because there is this narrative that this has been going on 14 years, and there have been a number of orders that we have respected and moved along a path in ensuring that children, for example, get equitable treatment according to Jordan's principle. But the order itself to pay only came down less than a year ago, and that is what has been judicially reviewed. But there has been that 14-year path that has led to a number of orders that has in fact changed the lives of children. So people shouldn't be left with the impression that nothing has happened. There is still much more work to do, and that's something that I look forward to sitting down with the parties in question and moving on historic compensation for people that have suffered discrimination at the hands of a broken childcare system. And let's also bear in mind that there is work to be done that can't be done in a context of a tribunal or a court, and that is long-term reform. That is all the self-determination discussions we've had with implementing C-92 in fixing the broken child welfare system, as well as the role of the provinces in making sure that children aren't apprehended. There still is an unacceptable rate of apprehension of Indigenous children in the child welfare system, and that needs to end.
I hear your response to whether you will appeal or not, that you just don't know at this point. So it's a maybe, but you have to do more more research on what the actual decision is. And I acknowledge that it just came out this afternoon. But knowing all of that and knowing the flack that your government took in the last parliament over the decision to appeal this tribunal's order, is it worth it to keep fighting it?
Again, this is an answer, David, that people will not necessarily find comfortable, but the Crown had legitimate objections to the role that the CHRT had played. Justice Favell has disagreed, and we acknowledge that. We will need to give that decision a thorough review that it merits, and then act accordingly. Again, I just don't want to leave people with the impression that nothing's been done and there haven't been a parallel process. This is not an effort to stall, it's an effort to get a sense of clarity, but we'll be able to take that back to the mediation parties and have ongoing productive discussions and making sure people do get properly compensated. We said it loud and clear that people that have suffered harm at the hands of the child welfare system will get compensated, and they will.
So, Minister, I think back to interviewing residential school survivors 20 years ago who were seeking compensation from the government, compensation from a variety of parties. And a lot of those people I talked to died before they got anything of what they began the legal process. They died. How long will people who are affected by this order need to wait for some kind of resolution, be it that the government gives up on appeals, be it that the government comes to the table and has an agreement, or be it that the Supreme Court of Canada perhaps orders that it take place, that this compensation take place? How much longer will they wait?
Yeah, and look, I take no comfort in stating that this class of children is much younger. It poses a particular set of complexities into traumatizing and re-traumatizing as people go through a claims process. And again, a day before a very important moment in Canadian history, I'm not going to point fingers at prior governments. I know when I became minister 2 years ago, sitting down with my team, making sure that we had our senior staff focused on putting together a framework to compensate people under this specific tribunal order. And I know the work that we've been doing at the mediation table, trying to stay out of courtrooms, making sure we're not traumatizing and re-traumatizing people that have already suffered harm, to make sure this moves quickly. This was a judicial review that we moved expediently on, and we will move expediently on getting an answer to that and then moving towards historic compensation. We have had discussions during the caretaker period, even during the election. So that has not been an impediment. Those are discussions that will continue, and they will be guided in part by this decision.
Minister, just before I wrap up our discussion, I want to go back to the person this began with, Cindy Blackstock, who co-initiated the original complaint. And she says your government behaved its way into this compensation order. We spoke to her a little earlier on the program.
Well, no, there's been no compensation. And what we have said is that these are human rights damages. You pay the $40,000 and then you can pay some other folks more. And keep in mind, David, that the government behaved its way into this compensation order. We had two evidence-based solutions in 2000 and in 2005 that if the government had acted on that, or even acted after we filed the case, there wouldn't be victims to compensate because those people wouldn't have been hurt.
So, Minister, I would end our conversation. Could or should the government just pay what has been ordered by the tribunal now and then make further damages or make further payments as damages warrant?
And look, I understand the spirit of that question, David. It's not something that it would be right for me to negotiate with you. Certainly, we want to move quickly on it. And I do want to acknowledge the work that Dr. Blackstock has done. She will be indispensable in long-term reform of a system that is broken and needs to be fixed. And she's been indispensable in achieving this historic these historic achievements for First Nations children. So I'll leave it at that.
Minister Miller, thank you very much for your time this afternoon.
Thank you, David.
Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.